Okay. And we are live. So welcome everyone to the Ad Hoc Commission on the Discipline System Fairness Subcommittee Expungement Working Group. I appreciate everybody attending today. I will call the roll first off. Michelle Anderson, I do not see yet. Ray Buenaventura.
Present.
Sarah Good, I do not see yet. Shalon Joseph, I know she was going to be a little bit late. Steve Moab.
Here.
And Martin Winfield. You are on mute, Martin. I can see you.
You're present. I thought I.
All right. Good to see you. At this time, I will ask for public comment. If there's anyone in the public that would like to make a comment, please raise your hand via the Zoom feature. At this time, I don't see anybody in the public that is raising their hand. So we can begin. Let me start to share my screen. It's going to take me one moment. All right. And I note that Michelle Anderson is here now, so I will mark her as present as well. So welcome everyone. Our agenda for today is to review the previous meeting. Since it's been a couple of weeks since we met, I just want to touch on the topics and highlight what we discussed at the last meeting. At the last meeting, there was a request to have an update on other states. And so we will provide that update on what other states are doing in terms of their disclosure on the internet or what they put on their websites. Then we will provide a comparison to other California regulatory agencies. So we looked at some other Department of Consumer Affairs agencies and how they handle what is on their website. And then we will review the discipline charges. Ron B is here with us, and he will be handling the second part of the meeting, and we'll go over the discipline charges that we use in the State Bar Court. And then we will also have an update. These last 2 points were requests made at the last meeting. So we'll have an update on the criminal conviction cases demographics. And then we will provide information on the population of disciplined attorneys, like how many attorneys are disciplined with public approvals, private approvals, probation, suspension, disbarment, and that other demographic information. So as a reminder of what we did last time, this working group is kind of focused in two areas. One is on the expungement process, and that would be a process that goes through the Supreme Court. We talked about the current expungement process last time, and we also talked about post-conviction types of expungement. We talked about the non-disciplinary expungement. Those are the administrative expungements that we currently have at the State Bar, that if someone doesn't pay their fees or complete their MCLE in a timely manner, if they meet certain criteria and the suspension was of a certain length in time, it's automatically expunged from the record. So we have an administrative expungement currently at the bar, and then we talked about sealing of records. And so this is one area of focus. This will be the focus at our next meeting. The other area of focus is what is publicly disclosed, so what is on the website. And at that previous meeting, we talked about what is on our websites. We discussed that the State Bar has two websites. One is the attorney profile page, where someone can look up an attorney and find out all their information, where they practice, phone numbers, where they went to school, and then any discipline history. And then we also have a separate website that our State Bar Court maintains that has all the case information. It's kind of the website of record. And so all of the case information is there. And we also talked about the different types of discipline. So, but we didn't get into that, and that's what we're going to get into more today. And then we talked about some of the other states and how they display things on their website and what is available via the website versus you have to email or call in. And that's another area where we're going to focus on today. So just making sure. So the other states follow up. At the last meeting, we presented an OGC memo that did an analysis of how other states display discipline on their website. And it also, whether or not the state bar needed to post things on their website. And the memo basically said that the state bar discloses it on the website as a public protection, but it is not required to. And then this memo also went into all the other states that require or that post things onto their website. At that time, the working group asked us to update this because it was back in 2016. And so I took a look at this memo and then went to the other states and researched whether or not things had changed. And of those 11 states that don't have discipline, were there any changes to actually bring discipline to those websites? And so of those states, those 11 states that didn't have prior discipline, 2 states still do not have discipline on their website. The only way you can get access to disciplinary information is through a phone call or calling in. And those states are Mississippi and South Dakota. One of the states, Oklahoma, instituted case filings on their website. So it's more like the state bar court. You can search the Supreme Court website of Oklahoma and find case information that way, but it is not searchable like our attorney profile page. And I found it very difficult to find information because there's a lot more cases than just attorney discipline on that website. And so you really had to know what you were looking for in order to find attorney discipline on that website. Another state, Kentucky, instituted it on their website, but it was really only the most severe discipline, and it only went back to 1999. And so if you were currently suspended or disbarred in Kentucky, then that would show up on their website. But as soon as that suspension was over, then the website would no longer have that suspension anywhere. So the next day, that suspension would be removed from the website. 2 other states, Alabama and Idaho, instituted a website where the discipline would be displayed, but they made it going forward. So they didn't go back and copy records to make them available online. They just chose the date that they implemented, and all discipline from that date in Idaho is 2016 and Alabama is 2018. The discipline going forward was available on the website. If it was prior to that, you would have to call in and you would have to request that discipline. The other 3 states that implemented it, it's very similar to California. I had to talk to several people to try and get how far back the records goes. Not a lot of people knew that, but Alaska, Louisiana, and New Mexico basically instituted the same thing that we have here in California, that all discipline is available and nothing is taken down from the website. As of last time, Florida and Texas have a 10-year where after 10 years, they remove the discipline from the website. And I confirm that that is still the practice, that they, after 10 years, they take the discipline down from the website, and it is still available. All of these disciplines are still available if you call in and request it. So that is kind of the review of other states. I'll take a quick pause to see if anybody has any questions on this right now. And seeing none, then I will continue on. Other California agencies. So there are other agencies that are regulatory within the Department of Consumer Affairs, and I researched a couple of those other agencies. One that stuck out to me was the Board of Registered Nursing, and I wanted to show the working group. This is from their website. I think it's a very transparent and easy to read chart. about what is available on their website and for how long. And so this chart will show you that depending on what the infraction is or the discipline is, relates to how long it is going to be displayed on the website. And so I found this very interesting, and the top paragraph talks about what this working group is specifically weighing. It's weighing the public protection and the public's right to know versus the licensee's right to fulfill their discipline and then move on from that discipline. And so I found this very informative. Not a lot of other agencies are as transparent as this. And so in using this, I thought it would be helpful to look at a comparison between the Board of Registered Nursing, the Medical Board of California, and attorneys, and where you can kind of look at what the impact of the discipline is and how each of those displayed on their individual websites. And so for a private reproval, there wasn't really an equivalent for nurses and doctors. They have educational letters, but it's not really discipline, so it didn't really apply. And so that's why you'll see there's an NA there. For public reprovals, you'll see attorneys, it's indefinitely on the website. For doctors, it's 10 years from the effective date. So after 10 years, it gets removed from the website. And for nurses on a public reproval, it is 3 years from the effective date. And I bring this up because we had public comment submitted to us at a previous meeting from an attorney who had a public reproval that was over 10 years ago, and that the challenges that the public commenter had in obtaining future employment. And so if he was a physician, for example, that would have been removed from the website, and definitely if he was a nurse, that would have been removed from the website. So ADP participation, alternative discipline program, that's for attorneys that have substance abuse or mental health issues. The doctor's program was sunsetted, so they didn't really have an equivalent, but the nursing program has a diversion program, and participation in the nursing program is private. It is not on their website. It's 100% confidential, so it's a little bit different than the participation in ADP for attorneys is public because of the stipulation. Probation, attorney website, it's public indefinitely. For doctors, it's public indefinitely. But for nurses, after 10 years from the effective date, it is removed from the website. And then suspension, there was a caveat to the doctors that if there's an interim suspension order, that doesn't stay on the website indefinitely. But if there was a suspension as a result of discipline, that does. So that is what that caveat is. And then suspension for nurses, it's 10 years from the effective date of the discipline. And then obviously for disbarment, or what they say revocation, it's on the website indefinitely. So this was just to provide context of, we looked at other states and what their practices are, and then to also look at other California agencies and how they handle discipline and what is on the website. Are there any questions about this comparison? I see Michelle, you have your hand up.
Yeah, my question is when we have disbarments in the attorney field, and you're saying it's public indefinitely, even if they get reinstated to the bar, is that correct?
I believe if they're reinstated, the discipline does stay on. But Steve, can you answer that? Or
if somebody is reinstated after being disbarred, yes, the original disbarment remains on the public profile on the state bar website, although it will say that they were essentially reinstated. It'll say that they've been returned to active status. Okay. And then, you know, on occasion, people will, you know, be disciplined after being reinstated, having been previously been disbarred. And that will also show up on the website, if that makes sense.
Yeah, I was thinking, I knew of an attorney, and he was sentenced to prison time, and he was disbarred, but then got reinstated. So I was curious as to whether or not the record would reflect. And then if it's discoverable, can people then still inquire about the reasons or receive the reports of the disciplinary action?
Generally, yes, they can then go get the case number from the profile page and go search the state bar court website for any documents that are posted there. Now, there was a transition some years ago, and I don't remember when, maybe 2018, 2019, maybe February 2019-ish, when it used to be that documents were posted on the attorney profile page itself. And after that transition, it was just the case number, and people would be directed to the state bar court website to go look for things. And so depending on when the discipline occurred relative to that transition, either the document itself would be posted, the decision, for example, of disbarment would be posted on the state bar website, or they would have to go to the state bar court website to find it.
Mr. Winfield, I see your hand is up.
Yeah, I had a question. Maybe it's just kind of an understanding of the ADP process. So they go through so an attorney will go through the ADP process. There will be a stipulation entered in prior to going to the ATP or is after the ADP?
Steve, you want to answer? I think I know the answer, but.
So I don't have a lot of experience in ADP, but my recollection is, and I could be wrong, so hopefully Justin it conforms with Justin's thought of the answer, is that there's a stipulation essentially to discipline, and there is a level of discipline that would be imposed if they are successful in ADP, and a level of discipline that is presumably higher if they that would be imposed if they are not successful in ADP. So it is a stipulation to discipline, and in that sense, yes, it's a stipulation, it's discipline, and therefore it's public. But it's sort of like a door A, door B. If you are successful in ADP, then this is the length of discipline that would be imposed, and if you are not successful, then this is the length of discipline.
And that is my recollection as well. And that's where the nursing program doesn't completely fit, because the nursing program is a true diversion program where if you successfully complete the nursing program, all the charges go away. So there's not a high and low.
So the ADP is actually kind of a, lack of a better term, post-conviction, or kind of a plea bargain.
Right.
Yeah. Okay. All right.
Yeah, that's a better analogy.
Mm.
Yeah, it's sort of like the judge saying, hey, if you go do 90-day rehab, then I'll give you credit for time served versus something else.
All right. Yeah, that more than a diversion. Yeah, I get it. Okay.
Yeah.
Okay. Well, then we will move on. At our last meeting, we talked about the discipline and the different charges that are used in the discipline process. And we talked about other diversion programs that have, divert away from discipline. And I think we talked about AB 3234 that allows for most misdemeanors to go into a diversion program now. There are some exceptions to the misdemeanors. I think it's anything to do with sexual assault or stalking. Those are not eligible, but all the other misdemeanors are eligible for a diversion program. And so when we were talking about this, we were saying, well, are there allegations like that we could look at to be expunged, maybe expunged from the website or eligible for the expungement process itself? And when we got into the discussion, the allegations don't always result in the same level of discipline. And that's kind of where we want to look at now. And that's what Ron is going to present here, is how it doesn't really translate to the criminal side. It's much different, and hopefully we'll get a greater understanding of how our system works, and then maybe look at it from a way that maybe we can't do it from the allegation or the charges side, but we can do it from the end result and discipline side as what may potentially be eligible for either removal from the website or when we talk about true expungement. So I'm going to turn it over to Ron B now, and he's going to walk you through answering some of the questions that came up at our last meeting. Ron, you're on mute. I don't know if you know you're on mute.
Good afternoon, everyone. Let me share my screen. So I put together some data in response to the follow-up questions that resulted from the discussions in the previous meeting. And here are the guiding questions that I used to pull the data. What are the charges for which attorneys are commonly disciplined? The second one is, what is the relationship between an attorney's demographic background, specifically about race, ethnicity, and gender, and the chance of being disciplined as a result of a criminal conviction in comparison to other non-criminal misconduct? And how many attorneys have a discipline record? The first one is based on cases disciplined in the past 2 to 3 years. And I pulled all of the charges, trying to organize them and display them in such a way that you'll be able to see some patterns. So the first thing I did is to look at the frequency of the charges and see whether there are some patterns across different disciplines. So here, just quickly, going through a couple of slides that you will be able to see the top 10 most frequent charges organized by discipline. So this one is disbarment. You can see here, based on the ranking 1 to 10, up to 10, it's already covered more than half of the cases. At the bottom, it shows 53% of the cases. So the top one is moral turpitude, dishonest, corruption, misrepresentation. The second is for those disciplined with probation or suspension. Again, up to 10, it's just the same proportion covered by these 10 charges. They are slightly different. I'll also show another table to give you some sense about the overlap or crossover across the different discipline outcomes in terms of charges. So here's the top 10 for probation suspension. And then the last one is on combined public and private reproval because of smaller number of cases. And again, the top 10 covers about just the 50% of the cases. Now, this is from a total of close to 200 charges. And it just shows that most frequent top 10 charges covers about 50%. But then if you look across the discipline outcome, different charges appear in different cases depending on the outcome, the discipline outcome. The top one here is different from what I showed for disbarment. It's a charge related to not responding to client inquiry. And then the second one is what I showed that's ranked the highest for disbarment. And then the third one is ranked the highest for probation, but substantially less for disbarment. So in terms of organizing the charges in order to have an understanding about, to answer that question about what's the charges people are commonly disciplined, a better way is to take into consideration a couple of things. One is, among the 400 or so cases that I looked at, on average, they have 7 charges. And if you look at an attorney's discipline history, they usually have more than one matter disciplined. So the issue of what is the pattern of misconduct across all of the cases and within a case with multiple charges, it's not easy to categorize unless we have a system of grouping the charges and have meaningful categories. That is what's currently being done here at the bar. We're trying to look at a totality of close to 500 distinct charge code and treat them as sharing some similar characteristics so that we can say, looking at a history of an attorney with all of the charges, we'll be able to identify certain patterns based on these categories. So once we have the categories cleaned up, tested, and potentially refining them, then the question about what's the common charges for an attorney will have more concise and complete information based on these categories.
And so, Ron, can we go back a second? Go back one more slide. I just want to make sure that the working group is understanding what this is. So these are the individual charges and then the results of those charges in discipline. So this is why we say it's very difficult to look at the charge, because one charge can result in probation, disbarment, public reproval, or private reproval, and it's the same charge. So that's why it would be hard to say we're going to expunge all of the failing to respond to client charges because they're involved in this. Now, one of the drawbacks of the data in this is this may not be the charge that was brought that caused them to be disbarred, but it is in among the charges for that case that caused them to be disbarred. So it was one of those things. So this is where it's a little bit hard to look at the data and pick out one thing and say this is something that we may potentially want to expunge, because it can have all ranges of discipline. And it is combined with other charges. It's not, and I don't want you to think that this charge alone is the reason why the end result.
That's an important point that, for those of you with criminal experience, when somebody gets sent to state prison, there's an abstract of judgment and they are sent to state prison. If there are 4 charges, each of them is assigned a sentence. And whether they are served consecutively or concurrently, each individual charge is given time in, for example, state prison. This, as Justin was saying, is not like that in the state bar discipline system. They're not disbarred on count 1 and then given concurrent time on count 2, or given probation on count 2 or something like that. It is sort of more of the overall picture, including aggravating factors and an analysis of mitigating factors and the facts of the case itself that lead to the total cumulative result of the length of discipline. So, trying to assign a weight to some of these things or wonder why this charge resulted in some disbarment is a little bit tough to untangle.
Are these business and profession code violations that I saw for the attorney discipline?
The statutes are the 6068 and the 6106, 6103. Those are business and professions code. The 4-100 is the old form of the rules of professional conduct. That has been updated. It's now 1.15 or something like that now, with the adoption of the new rules in November of 2018. But 3-110, that's all the old rules. There's also the 1.15 D4 down at number 9 on the current side. That's the new version of the rules of professional conduct.
Thank you.
Moving on to the next question, has to do with the extent to which an attorney could be disciplined as a result of either criminal or non-criminal conviction case, and comparing across different race, ethnicity, and gender subgroups to see whether the probability of criminal conviction leading to discipline is similar And the result here is based on discipline cases over the past 6 years, 2015 to 2020. And the overall is about 20% at the bottom of that red highlighted area. And you should also note there's a large number of attorneys where we don't have the race, ethnicity, and gender information. They account for about 15% of the total. But the key point here is highlighted in red for Black male attorney. It's 8.6% compared to the overall 20%. That's a substantial difference, and it's lower than the overall population, or actually compared to any other subgroups. So what that says is Black male attorney, they don't have a higher chance of being disciplined as a result of criminal conviction case. To look at the same issue, but shifting the time frame a little bit to more recent cases. And the reason I moved to a more recent cohort of cases is in the past 2 years, the source of criminal conviction cases came from not only the traditional reference source, including court prosecuting office or self-referral for criminal conviction records, but primarily about half of the criminal cases came from the project of fingerprinting, and we call it CORI cases. And because the characteristics of the CORI criminal cases are quite different from the traditional criminal cases, this is another comparison to look at the same issue. And here, partly because the number of cases involved is smaller, but also the larger number of criminal conviction cases as part of the discipline compared to the previous period, there's no statistically significant difference across the groups about the chance of being disciplined due to criminal conviction.
Steve, I see you have your hand up.
Thanks, Justin. Ron, sorry to interrupt you. Just looking at this, one of the questions that it poses for me is, I assume from the wording of the slide that this includes all disciplines and does not break out, for example, disbarments from C cases, from criminal conviction matters, as opposed to other disciplines. Is that right?
Yes, it includes all disciplines, criminal or non-criminal.
No, okay. So, for example, one of the issues raised in Farkas is that Black men are more likely to be disbarred with certain circumstances, et cetera, and that this seems to undercut it, at least in the sense of based on criminal conviction matters. And I'm wondering if you were to disaggregate the disbarments from other disciplines, whether that would reflect a similar trend as the Farkas report showed, or whether criminal conviction matters are a completely different thing with a different trend.
Yeah, I see. Yeah, I see your question. That would require just breaking up the sample into disbarment versus other discipline and see whether that difference across the subgroups hold up here or it shows a different pattern. I can follow up to look at it that way.
Okay.
Real quick. So this is real quick. So this is just saying that the percentage of Black men that are disciplined is less because of criminal convictions, but it's not comparing the other, like it's not weighted on how Black men are disciplined compared to the whole, correct?
Right, it's not answering the question of whether Black male attorney or any other group has a higher chance of being disciplined at all, regardless of the type of conduct, criminal or non-criminal. It's only answering the question about, given an attorney is disciplined, whether they have a higher chance of being disciplined as a result of criminal conviction or not.
Or not, okay, I get it, okay.
And that was the question last time was, are Black men, more likely to be disciplined because of C cases? And the data currently shows them kind of a little bit less.
But this is, I don't think the numbers would show any different just looking at the raw numbers, 5 and 152. Right. But this only shows that the percentage of Black men's total discipline is criminal. It's because of criminal convictions. As opposed to, in this sense, it doesn't seem like it'd be any different because the total of Black men is 8 and the total is 437. We're looking at what? That's even lower. We're looking at about 4%, or even if it's that 5%. But it doesn't give you the criminal discipline as a whole. Like, are Black men, do they get more discipline as a result of criminal convictions compared to the other groups?
Right.
Or is that coming up later? Did I jump in?
Justin, did you notice that Leah's had her hand raised?
Yeah. So what's your question? So your question?
So it's not really a question, but this doesn't say if Black men are more disciplined as a result of criminal convictions compared to the other groups.
But
this is just saying the percentage of criminal disciplines out of the total amount of disciplines for Black men.
Right.
Okay.
So I think that was my question as well. So like for white men, is it saying out of, like, for example, 100 disciplines, 21.4 are the result of a criminal conviction?
That's correct.
And for Black men, out of 100 disciplines, 8.6 are because of a criminal conviction.
Mm-hmm.
In order to know, I am so sorry because I've been in and out of these meetings, so I'm not exactly sure why we're looking at this. But in order to understand this data, wouldn't we need to know what the criminal conviction data itself looks like in terms of the racial distribution? Meaning the information we get from DOJ, like, isn't that important, looking at the demographics of just the information we're getting?
This population doesn't touch the cases coming from DOJ, cases disciplined in 2015 to 2020, and this population does.
Mm-hmm.
Out of 150 here, criminal conviction cases leading to discipline, about half of them came from DOJ.
Mm-hmm. Well, whether it comes from DOJ or not, I guess what I'm saying is we have 150 cases. Let's say we had 300 conviction notices, right? That translated somehow into only 150 cases that got disciplined. Wouldn't it be important for us to know the racial demographics of those original 300 convictions? Or even if it was 152 notices of convictions received, wouldn't we want to know what the racial distribution was of those? Like, for example, if 5% of the conviction data, 5% of the 152 conviction notices we got, of course, corresponded with Black men, would it be meaningful that 17.9%? I think the answer is no.
So let me rephrase your question. Is it trying to figure out, given 100 cases that we got from DOJ, and then we know the different proportion across the different subgroups, whether a case from DOJ notice leading to discipline is similar, the chance of getting disciplined from DOJ is similar across the groups?
And that this doesn't tell us that, right?
No, this don't know.
It's a different
152, half of it came from Corey, about 75 of them. And remember, we have probably 4,000 DOJ notices in the past 2 years.
Yeah, but I think regardless of the source, DOJ or other, this analysis isn't really looking at like which criminal conviction notices, either self-reported, reported from DA's offices or through DOJ. It's not telling us which ones end up in discipline.
No, it
That-
doesn't.
Yeah, sorry for confusing us.
No, it doesn't even answer the question about the disparity across the groups in the overall probability of discipline. In the way that we are comparing data, it's simply answering the question of, given a discipline, whether the chance of discipline resulting from criminal versus non-criminal is the same.
I have a question, if I may. In your analysis of the convictions per se, were you able to discern the nature of the convictions, meaning the actual penal code violation, what exactly, what categories they were in? And then secondly, if the convictions were the result of an acceptance of responsibility by pleading guilty, was it a trial where they were found guilty? Was it a more like a deferred conviction? That kind of thing. I'm interested in finding out, what does a conviction mean when it came to your research?
Before Ron answers that, I'll just throw in there that a deferred entry of judgment is not generally a conviction for our purposes. It's got to be final. And so it's not going to be a final conviction. So it wouldn't be subject to discipline until that judgment is actually entered. So when you're talking about a deferred entry of judgment, and if they complete a program, it will be dismissed or whatever, there's no discipline that would result from that.
Okay.
Related to the first part about the specific type of charges, either severity or type of criminal offense, we do have the description, but in terms of categorizing them, it's worse than the professional code, because the original charge description came from a variety of jurisdictions. So whatever the data entry was, we have it, and it's very difficult to parse the text and then categorize them. We haven't been, probably a few thousand distinct criminal charge descriptions. So we haven't been able to make sense of the type of offense by categorizing them, other than maybe searching some keywords to see how many of them actually involves DUI, for example.
Okay. And then the question about how did you get to the conviction? Was it an admission of guilt, or were they trials and a finding of guilt? Do you know?
As far as core data, I've not seen in DOJ records any reference to the manner of disposition through trial or plea guilt. I'm not sure about the certificate of a conviction records from the court, to what extent you have those details.
All right, thank you.
So this is the last question related to what are the types of discipline and how many attorneys are involved. If we look at all of the attorneys, and all of the attorneys here includes attorneys with the current status active, inactive, not eligible, and also those who've been disbarred. So here, looking at a total of near 7,000 attorneys with a discipline records, you'll be able to see on the website. About 60% of them, discipline occurred more than 10 years ago. And then it's broken out here by the different types of a discipline, the length of time since it occurred. So for private reproval, for example, you could see that 80% of those cases occurred more than 10 years ago. Any questions so far?
Okay.
Just a quick question, Ron. So of all the discipline that's been levied, 60% of it occurred more than 10 years ago?
Of all the disciplines for the current population, yes.
Wow. That's kind of surprising.
And so that I think that last slide was important to kind of show the population of people that could be impacted directly by any potential recommendations by this working group. If you look at, private approvals or public approvals over 10 years, and granted those columns include active or inactive or not eligible to practice, and then also the disbarred, but they have not, there's a subset in there that have been practicing. That's since the last discipline, right, Ron?
Yes.
So that 10 years, it's since their last discipline. It's been 10 years in that subset of 700 people on the public and private approvals. Welcome, Sarah. I see you have joined us now.
I was listening in, so it's okay.
Okay, good. And I see Shalon is here too. So that's what we have to present.
Yeah, sorry for being late. Sorry.
No worries. So that's what I have to present to the working group today. And now I'm hoping to have a discussion of, are there other things that the working group would like for staff to bring back on to inform them to make potential recommendations, or have a discussion on whether or not they think there are certain levels of discipline that could potentially come up for recommendations on removing from the website, or kind of, I'd like to hear from the working group where they feel they're at right now, and if there is more research that is needed, or if they're comfortable discussing recommendations now.
I would like to just put out there that, well, first of all, thank you for the presentation. Those charts and things whatnot were very helpful. So I would like to put out there a more aggressive position in terms of the 10 years. I think we need to go lower than the 10 years. Obviously, 10 years seems to be the mark that seems to be what is happening, but I think we're in a different time, and I think that for a lawyer, if a lawyer is going to practice law for 20 years, so 10 years of their practice is already going to be negatively impacted. So that's half their career. And so I think we should go lower than 10. If the nurses go as much as 3 years, maybe we should do 5. But I certainly don't think we need to stay just at 10, but we need to modify that number in a way that makes sense. And I just think that we could do better. So that's my thought. Thank you.
Sarah?
Yeah, I agree with Ray that we should go lower. And maybe there's some subset where 3 years would be appropriate and some where 5 years would be appropriate. But 10 years of a lawyer's career impacts that career, right? It impacts that career trajectory. It impacts whether or not they can continue to practice law. So it's not just taking them necessarily, it's a huge impact. And I like the idea of looking at something more like 3 or 5 year, but certainly not 10.
I'm in agreement with what everybody has said, because I do believe that if you have a disciplinary record for 10 years, it is impossible to restart that with that much negativity. But I do believe that perhaps it should be charge based, or depending on the conduct, on whether we institute 3 or 5 years.
Okay, Mr. Winfield.
Yeah, I agree. It should be lower, 3 or 5. And then another thing is, like with these cases, they don't, something can happen, and the bar case could probably last for a year or so, right? Like it's not a short amount of time. So considering that, by the time that it becomes effective, it should be a shorter period of time, because then if you're talking 10 years, it could affect them for like 12, 13 years. I don't know, depending on the case. But yeah, I think 3, 5, and depending on the subject matter of the conviction and the level of it, even lower than 3. Have other options where it can take it down even further. So that's my thought.
Okay, I will come back to Leah. I see your hands raised.
Yeah, I wonder how the group feels about, is that irrespective of whether or not any subsequent complaint has come in? And I ask that in full recognition of the fact that Black male attorneys are more likely to be complained about. So I'm cautious about that as a factor, but just thinking about kind of public perception, stakeholder perception about this move, I do think, just would ask the group, are there any circumstances under which you might suggest it not come down based on subsequent conduct?
I see Ms. Anderson has her hand up.
I just think that as, I guess, similarly in criminal law, there's prior ability. So if you've done it and you've done it before, logic would reason that your penalty or the amount or the length of the time of the expungement perhaps should be extended. So maybe you look at things in the context. So, this is the first time somebody's done it and what the level of the offense is, and then you determine the expungement. But if you have a repeat level of conduct, then it doesn't make sense that you would give that person the same benefit of the doubt as somebody who has had no disciplinary record, and this is their first time doing it, but realizing when you're in a system where one particular ethnicity is targeted or complained about more than another, I could see how that would still cause a disproportionate impact in that community.
Steve, your hand is up.
Thank you. I did want to respond just to one of the comments from Mr. Winfield about the amount of time, and he's absolutely right. It does take a lot of time to investigate one of these cases and get it filed in state bar court, although those cases are confidential during that period. So it would not necessarily impact the lawyer while the case is being investigated, because it would not appear on the website during that time. It only appears on the website once it's in state bar court, and those cases tend to move fairly quickly. So while there may be some cases in individual delays, there may be some delays in individual cases. It's not a situation generally where there's significant lengthy delays overall. As far as the discussion of charges and disciplines that could be expunged, I think we're having a separate conversation later about the actual expungement. Right now, we're just talking about the website. And obviously, we do have an obligation to still provide information to the public. I do think that we would need to look at it in terms not only of the charge for which they were found culpable in state bar court or disciplined, but also the nature of the discipline that was imposed, right? We've been talking a little bit about private reprovals or what all it is. And we could have, even if we were to say that all of them should be removed from the website at some point, I expect that we might want to approach it with a little bit more nuance and say that, hey, look, if it's an actual suspension, maybe that should stay on longer than a private reproval, for example. And in response to Leah's question about the subsequent complaints, and this is also a little bit difficult because, as she said, Black male attorneys are more likely to get complaints. And that was one of the factors that is considered in the fact that Black male attorneys are more likely to be disbarred or be suspended. But we get a lot of complaints that have no merit. And so I think the fact that a complaint comes in and of itself is not necessarily significant, but it does seem to me that if that attorney is then subsequently disciplined, that maybe we want to look at that differently. But again, I'm not sure how to pull out or disentangle the factor of the fact that they get more complaints may lead to more discipline. So we'd have to consider that too.
If I can just also comment. So I see it as if one attorney gets disciplined and they are subject to the 5-year sort of mark, that's the penalty. That's the status quo for that violation. If a subsequent violation occurs, then that should be treated on its own and then dealt with on its own and have no impact on that 5-year in terms of increasing that 5-year mark. Conversely, what I was hoping we could build into this, and I'm just assuming it's the 5-year that we're suggesting. I think there should be a way for that attorney to actually petition to reduce that 5 years. So if you see progress, rehabilitation, good conduct, real, change in the behavior to where maybe there's no complaints for 2.5 years, then that attorney should be able to petition the state bar to actually get it removed even less than that. So maybe the penalty for getting a subsequent complaint that's been sustained should be they don't get to petition an early termination or early reduction of that 5-year period. That was my comment. Thank you.
Okay, so to try and kind of narrow down the conversation, I've heard various lengths of time. I think it might be useful to go over the various levels of discipline and see whether or not there's consensus around a length of time. And as Steve mentioned, and I want to be perfectly clear here, we're talking about removal from the website right now. We're not talking about expungement. That's a future conversation. We may have similar outcomes. We may think that, petition for expungement or automatic expungement for these charges should happen. But right now, I'm just trying to focus this conversation on the website. And so at the lowest level of discipline we have is the private reproval that is public. And Mr. Winfield, I see your hands up. Did you have a comment?
Oh yeah, I just wanted to comment what we were talking about, because what I was talking about on the website as well. And be honest with you, when I think about it, as I think more about the discipline, I think once that person does whatever is required from them, then it should be removed, like within a year or, pretty much soon after that. And then the maximum would be up to 5 years where it's included on the website. That would be my thought on it. So if there was a suspension for 2 years, it stays on there, and then another year or two after that, depending on it. My thought.
Okay, Leah, I see your hands up.
I'm assuming though that wouldn't hold true for disbarment unless there was a reinstatement, right? Because if someone was just disbarred, we wouldn't take that down after 5 years, correct? Just because there is concern about the unauthorized practice of law, for example.
Oh, definitely not that.
Well, maybe we could remove their profile. That would be different. And that's something that we don't do now. But I just wanted to highlight that. I have to jump off now. I'm sorry.
Okay. So if we could go by level of discipline and talk about. So the lowest level is a private reproval that is public. So that happens on the occasion where the notice of disciplinary charges, which is public, ultimately results in a private reproval. That is currently public on the website. How does the working group, since the ultimate discipline should have been private, and if it was come to prior to the notice of disciplinary charges, it would have been private. How long does the working group think that should remain on the website?
Can somebody give me just a couple of examples of situations where there might be a private reproval, just to orient me a little bit, like common situations?
And also, I mean, just to tack on to what Sarah's saying, and I'm sorry if you did this in your presentation and I missed it because I was late. If it is private, then why are we making it public? I mean, why is it public on the website?
Well, it's public because all the notice, anytime we have a notice of disciplinary charges, that is public. And if the ultimate resolution of that, subsequent facts came to light, there's negotiations. And so the ultimate agreement for the discipline is private. That notice of disciplinary charges does not come down from the website, being that it was private. And Steve, you can correct me if I'm wrong on that.
No, that's right. And I don't have, factual examples or charge examples, but the procedural example is exactly what Justin just said. It is that, the case is moving forward, and we filed the case in state bar court. We filed the notice of disciplinary charges. That is public, and therefore, and thereafter, it is resolved for something that is private. It's called a public-private or private, and so it is posted on the website because the case itself was public, but it is still considered a private reproval, even though it's in that sense public, but it's not publicized. Like, we don't otherwise publicize it, and so it is in that sense still sort of a private, although it's a little bit of a hybrid.
Is it on the attorney's profile page?
It is, but it's not otherwise publicized.
And I guess the rationale would be, right, that there is a concern about harm to the public, I guess, right? That there was a disciplinary proceeding that did result in the lowest amount of discipline being imposed, but that there is a public interest in it. I mean, maybe that category goes to 3 years, right? Maybe that's an example of something where it should come off after 3 years. Assuming, good behavior or whatever you want to say, it just should automatically come off.
Yeah, I think that one should just, if they're required to do something, once they complete whatever they were supposed to complete, it should come off. If it's a private reproval, I mean, that's my thoughts on it. I don't think it should stay any longer than it has to.
I tend to agree with that. I mean, I think that if the violation is such that we don't think it needs to be publicized because of the nature of what they did, and the punishment should be private, that once you complete whatever it is that's being asked of you, why is it still public?
Maybe that should be a situation in which it's upon completion of whatever disciplinary measures they have, or 1 year. And I say that because, for instance, what if they told me I needed to take a professional responsibility class because I did something that was considered unethical in whatever, and they feel that if I just went through this class and it takes me, maybe a couple of weeks or maybe even 6 weeks to complete the class, and then I've done it, that, a year or the completion of the act, whichever is lowest, should come first, should be the period of time.
So I'm hearing a little variation. We started at 3 years and then completion of whatever the conditions of the private approval are, or a year. Do we?
Can we kind of see all of them all together? Do you have like can you share screen and put them all up? Because that might be more useful.
Sure. Let me.
And my thought on the private approval, just kind of going on what Stephen was saying, the only reason why it is published is because there was a case that was filed in court. It's I don't think it's really was there for the safety of the public. And maybe I'm misreading what Stephen was saying, but it's kind of there. The private approval is kind of on the profile just because the court case and it being held in court makes it public. So there's nothing against basically putting it on the profile. Is that kind of correct, Stephen? That I'm reading from it, what you're saying?
Yeah, in some ways that's right. I mean, it may be a private approval. There may be conditions with that, as you guys have all mentioned. It certainly, we moved forward with it because we felt like there was a public protection issue, and so we thought it was appropriate that there be discipline imposed and that it be public discipline. We could issue a warning letter for something that we thought was not appropriate, at least at the time that we filed it. And we felt like public discipline would be appropriate moving forward. It may be that at that point they provided us facts not about the offense itself, but about about mitigation or something along those lines that then allowed us to reanalyze the case against our case law and against the standards for imposing discipline on attorneys. That said, okay, now it's going to move it away from what the presumed discipline is and instead into a reproval, and at that a private reproval. And so that would be a public private. It is also important to note that in some cases, if somebody were to know through the news or through the state bar court website, find that case, they would still be able to find conceivably that it was a public-private reproval. But in some ways, I mean, the private reproval is somewhat de minimis, and in some ways it may be inure to the benefit of the attorney to be able to say, look, it was a private reproval, which is the smallest level of discipline that can be imposed, so on and so forth. Just something to think about as well. If somebody knows about that case, then it may be helpful to the attorney to know that it was relatively de minimis.
Yeah, but I guess if people find out on your profile, it's not really, you don't really get a chance to explain it. It's kind of, I think that's
right. In this case, the profile would explain itself, right? Yeah. In this case, if it's a private reproval, the profile essentially says, wasn't that big of a deal.
Yeah, I don't know if the public would know that, but yeah,
I think, after the discussion, I'm good with the 1 year when conditions are met. Public reproval, I think, should stay on there for 3 years myself.
I see noddings from Ms. Joseph and Ms. Anderson. I don't know if anybody has a differing opinion.
Well, I mean, I'm not gonna, I don't want to quibble individually. I mean, I guess I would just say that the consumer protection attorney in me thinks about what the public sees and what they would expect to see when they come to the regulatory agency's website and what's on there. And unless we're going to sort of say, what we're showing you is only part of what you could see, so call us for more information. In some ways I could see the public thinking that this is misleading and that this is the state bar protecting, members of the state bar, and really feeling somewhat, I won't say ripped off, but confused about why we're not being transparent about what the discipline history is. I'm not suggesting there aren't good reasons for it, as you guys have all mentioned, but I'm also trying to put myself in the from the perspective of the consumer and what they would expect to see when they went there.
Well, could we put, oh, sorry.
I was just gonna say, we just outlined, what gets posted and when and the parameters. And given that we're trying to sort of redress some wrongs, I think 3 years is plenty long enough. And again, if somebody gets into trouble and does something else, then that's kind of a separate matter.
Yeah, I mean, I think we could put, kind of how the nursing board was transparent on what they decide to disclose. You can kind of put that on there, let them know, it only covers public approvals for 3 years, private approvals for conditions met, blah, blah, blah. And then if they had any further questions to contact, it's kind of I think it's more of a balancing of what
I'm going to jump ahead. I think the probation with stayed suspension should be the same. I think it should be 3 years as well. Because presumably if somebody does something improper during that time period, then they get actually suspended, right? So I like the idea of that also being 3 years.
So
I'm sorry, just for clarification, Sarah, are you saying 3 years after the probation ends or 3 years like from the start of probation?
From the start of probation, but I guess I would assume probation would have ended.
Oh, right. I mean, I'm
Yeah.
just wondering, like,
Yeah.
if probation is 3 years, then are we saying that it goes off of the website at the time that probation is done, or do we want it on the website longer than the person's on probation?
I don't think so.
Yeah.
Is it possible that somebody would be on probation for more than 3 years?
I don't know the answer to that, Ron or Steve. That
I would say that I always regret saying always or never, but I think that most are 3 years or less. I don't want to say that it never happens that there are longer probations, but I think they're generally at 3 years or less.
Then maybe we say 3 years, or whenever the probation concludes, whichever is shorter, right? So then it's at least 3 years, but it sort of covers those rare instances where it might be longer.
Is this automatic, or is somebody having a petition for this?
that is up for the working group to decide whether or not these are automatic scrubbing from the website or if it's petition based.
Because my vote would be automatic.
Maybe we should just figure out the time period and then go back to that.
Okay.
And then the probation with the actual suspension, I kind of feel as if that should be 5 years. But I don't know how others feel. I mean, that's a really serious issue and problem, and certainly, a public protection issue.
I saw a thumbs up. Anybody else want to weigh in?
I mean, feel compelled to speak. I think that 5 years would be the absolute minimum, frankly. And I mean, I think it's got to be, frankly, I would think it would be more, but even if you were going to go with 5, I would say that that's got to be 5 years following the, their reinstatement or their the conclusion of probation, whichever is later.
Give us an example of situations in which somebody's like, for which offenses is somebody actually suspended?
Again, it's hard to say, to give you an example, because it's generally not that they're suspended for a single, crime or a single allegation in our parlance, but it's more sort of an overall based on a course of conduct or whatever. It could be a misappropriation, right? Or it could be making misrepresentations to a court. And then depending on the seriousness of it and an assessment of the entire aggravating and mitigating factors, the court may say, okay, this warrants an actual suspension. And actual suspensions can, range from 30 days to, 2 years, 3 years, whatever. And it's generally, if they're suspended for, there's also a clause that says that the standard is if it's 2 years or longer, that they have to essentially petition to be reinstated. So we call it a mini reinstatement. It's not a disbarment reinstatement, but it's a return to active practice, if you will. And it could also apply to actual suspensions that are less than 2 years. If the court says, look, I'm going to give them a 1-year suspension or an 18-month suspension, but I want them to go through this process to demonstrate that they should be returned to active practice.
So I guess if I'm hearing it correctly, is it fair to say that this is kind of a progression of discipline in a sense? Like if you do one thing, then you may get a private, reproval. But if you're engaged in a course of conduct or a course of behaviors, then you're going to be looking at a suspension. So, I mean, if we're characterizing it as, I guess to me, it matters whether someone's being suspended because they did 5 things wrong versus one thing that's really bad. In my mind, that differentiation is important to assessing the time.
But maybe Steve's suggestion of 5 years, after you've been reinstated is a good one, because then if you're suspended for 30 days, it's a shorter period of time. If you're suspended for 2 years, that sounds very serious to me. And then it's a little bit longer. So maybe that suggestion sort of takes into account the length of the suspension, the severity of the misconduct, and the public protection issue in a way. Maybe that's the way to go.
I'm in agreement. I think it should be for the actual suspensions, 5 years within after reinstatement. I'm thinking, I just keep going back to this one person that I know, and it's probably horrible, but he was in sexual relations with his client and did various other things and ended up, turning in his bar card for a prison card, but he did get reinstated at some point. So, I think the public still needs to have warning of set more serious conduct. So I think you definitely need to have more of a sliding scale on more serious crimes.
So is that because I heard 2 things from Steve. One is reinstatement and one is after the end of probation. I think Steve was advocating for once the probation ended, but I'm hearing from other people that it's after the reinstatement. I'm just trying to make sure that I'm getting it correct.
So the actual suspension continues until they're reinstated. Now, in some circumstances, it's automatic. It's after they've served their 30 days or whatever. And in some circumstances, they need to petition the court to be reinstated, to return to active status. So either way, that would be the end of their suspension, if that makes sense.
Yeah.
So you're saying the language of reinstatement is more defined than the conclusion of probation?
No, both are defined. They just may not be the same date. For example, somebody may be placed on 3 years of probation with, 2 years of actual suspension and a 1.2C clause, which is they have to petition for reinstatement. And so it may be that they are reinstated immediately after 2 years. It may be that they're reinstated at 4 years. So my suggestion was that it be 5 years from reinstatement or the conclusion of probation, whichever is later. If, for example, they are reinstated at 4 years, we would go 5 years from then.
How long is probation typically, though? I don't like that. If somebody's suspended for 30 days, I think 5 years from them being reinstated is plenty of punishment and deterrence. And if they've got a 2-year probationary period, then it effectively makes it 7 years, which I think is too much.
I can't say typically what the term of probation is. You frequently see them for a year or something like that. I don't know. I'm going to go out on a limb and say it's generally calibrated to the suspension, both the stayed and the actual. But I don't know if at 30 days it's always a year, or sometimes it's 2, or maybe sometimes it's 9 months or something like that.
I guess then I'm fine with the reinstatement language, but I don't want to also include the termination of probation, because I view that as a longer time period with sort of more adverse consequences, a longer time period. So I kind of like it as written myself.
I hate to disagree, but I think 5 years from reinstatement or at the after the conclusion of probation, because I believe that if the probationary period was longer, it is for a reason, and it's probably for a more serious crime that the public needs to be notified of. And so that's my 2 cents.
I think that's right, except that I also agree with Sarah that if someone gets suspended for 30 days, that's different than someone getting suspended for 2 years. And that the time frame, there should be some distinction. I mean, if you're saying that the punishment goes with the offense, then 30 days seems to me to be, there's some factors that go into giving someone 30 versus 2. And so the years that from reinstatement should also mirror that punishment in my mind. And so I think, yes, if someone is disbarred or, is suspended for 2 years and then has to petition, that Steve is right, we should do 5 years from the date of reinstatement. But if someone is, suspended for 30 days and doesn't have to petition, to be reinstated, I just think 5 years for them is a little bit too much.
How often, when somebody's coming off of suspension, reinstated, that they're given probation? How often?
I'm not sure I understand the question, Mr. Winfield. I'm sorry.
Well, probation with actual suspension. So if they're suspended and they reinstate to be reinstated, then they're on probation, correct? After that?
Yes.
I said, how often is that? Is it automatic you're on probation after suspension when you're reinstated?
It depends on when you're reinstated. For example, if you have to petition to be reinstated, your normal probation may have expired, to my knowledge. But generally, anytime you are suspended, you are also placed on probation. So if somebody is given a 30-day actual suspension, they are also placed on probation.
Okay, so
does that answer your question?
Yeah, it does. Then
Okay.
I agree with Sarah and Shalon that it should be 5 days from reinstatement.
So Steve, and I hesitate to ask you because you don't like to talk about generalities, but is there a difference in severity on whether it's an automatic reinstatement versus petition reinstatement?
Is there a difference in severity? What do you mean by that? A difference in the severity of the allegation, or?
Well, I'm just saying, because I think that what everybody's talking about is like 30 days suspension and it's automatically reinstated is much different than a 2-year suspension. And the 2-year suspension, is that mostly petition because it's longer? Is there, a correlation between the length of the suspension and whether or not it's an automatic reinstatement or a petition reinstatement?
Yeah, the 1.2C rule applies, generally with exceptions to 2 years or longer, but can be ordered by the court for shorter suspensions also. So we have seen suspensions that were 18 months, but the court said, but I'm also going to impose a condition under 1.2C that will require that this respondent, petition to be readmitted, to be returned to active status.
Okay.
Does that answer your question?
Yes, kind of. I think I understand the two different distinctions on this one. And I think we can maybe take a look at the data and maybe bring something back at the next meeting to get better understanding of what the length of suspension and the length of probation is more typically than just trying to come up with it. Would that be helpful? Or do we think that we have consensus here to just do it from the reinstatement?
I'm okay going with the reinstatement, but if someone else wants more information, I'm certainly not opposed to that.
Okay. Well, I will leave it as is for now. And then the last one we have is disbarment. And as Steve mentioned previously, or Leah, someone mentioned previously, that this is the deterrent for the unauthorized practice of law, is why this is usually kept on the website until the attorney is deceased, then it's removed. But I don't know if there's any changes that want to be done with this, or if this is fine as is.
I mean, could we make that one 10 years? But then, we haven't talked about, do you need to petition and is there discretion? But I would suggest something along the lines of 10 years, maybe more, but that also a petition would need to be made, finding of kind of good faith and effort, and to ensure that the public wouldn't be harmed by this being removed from the website. Thoughts, anybody?
I would support keeping it on the website.
Sorry, I didn't hear your comment, Steve. Sorry.
Oh, sorry. I said I would support keeping it on the website.
And Steve, to be clear, that would be forever?
Well, it's removed upon the death of the attorney at this point. And yes, it would. So I would keep with that rule. And as Justin said, it is to combat the unauthorized practice of law, which does happen.
If I may, I wanted to bring something up. And this might be a more, I don't know if this is too big of an issue to tackle. I think we need to at least recognize it. So when we're talking about putting something on the website and we're putting a time limit on when, it's going to be not on the website. That's actually not true, in that once you put it on the website, once you put it on the net, it's there for people to discover, regardless if you have deleted it from the bar site or not. And so, I mean, I'm, you know, they have all kinds of other websites and applications that will freeze day by day in time, and you can go back to umpteen years. And so I think it should be mentioned that maybe the model of having everything reported on the website doesn't really serve our purpose when we're talking about trying to control the amount of information that's out there. And so maybe it's not something we can really, maybe we don't have a choice because of the modern day internet and what has become of our society. But are we doing really anything productive if ultimately it's discoverable on the internet? And so I think it's something to think about. Maybe the reporting of the attorneys and things like that should be reported another way. I don't really have a model for that other than what's on the website, but I mean, I think it should be noted and recognized for the problem that it is. Thank you.
So are there any other comments on disbarment? I heard from Sarah and Steve who had differing opinions.
I think for disbarment, it should be on there, on the website. It should remain. I just think it's such a serious situation that for protection of the public, they need to know. And that's my opinion.
Anyone else? Because right now I have that as 2-1. Shalon, are you?
I'm muted. I saw that. I think that it should stay on as well. If you're disbarred, I feel like it should stay on the website for that. And one reason that makes me think that way is that when you're doing habeas work and people's petitions aren't looked at for 10 years, maybe, or so, or longer, sometimes if the claim is ineffective assistance of counsel, you're going back and looking at disbarment as a factor. And if that is taken off before you are actually right for looking at the issue, I think that is a disadvantage to the clients that are bringing the petitions based on ineffective assistance of counsel. And sometimes I think that, I mean, a lot of the time for me, that factors into the analysis. If there was a subsequent disbarment and the claims are the same and the reasons why the disbarment happened, it somewhat corroborates a claim of ineffective assistance of counsel, but those claims are not often looked at within a 10-year period. And so I think it is beneficial to have it on there, actually, for how it is right now.
Okay. So now that we've kind of discussed the individual levels of discipline, is there a conversation to be had on whether or not this is automatic or it's petition? And should there be a difference between the levels of discipline, whether it be automatic, or should they all be automatic or all be petition? What is the, Sarah, you have your hand raised.
So I was going to suggest that the first 3 levels be automatic, and then the one where someone is actually suspended involve a petition to the court, and discretion should be involved. And I will also say the habeas argument kind of persuaded me. So I guess I'm okay there. You know, I was thinking of a situation where I knew somebody who didn't do their MCLE requirements and then just never responded to anything from the bar and then got disbarred, which is probably the most benign disbarment that you could imagine. And it just, you know, so I sort of think about that when I think about disbarment, in addition to, you know, really egregious situations of theft and of funds and all of that kind of stuff. But I mean, the habeas cases, absolutely, they're 2-3 decades later potentially. So I understand that. So I've come around there.
Any other thoughts?
I know that we seem to have decided, I'm just sort of revisiting the timeframes. My position is still that the 3 years and 5 years should run from the end, not from the beginning. But I understand that I'm outvoted if we're voting. That's that I've been outvoted. If we're talking, I've been out-talked.
Well, we're still taking this back to the committee, and I think, you know, we don't necessarily speak with one voice, right? So your view is certainly respected, and you're entitled to air it. So, as we all are.
So the initial recommendation was that the first 3 of the lower levels of discipline be automatic, but the suspension be petition. Anything that had actual suspension be a petition to come off after 5 years from reinstatement. I'm looking for agreement or disagreement.
Yes.
Yes, I agree with Sarah.
Okay, there's consensus there. Okay, I don't think we have to decide who they're going to petition to. I think that's something that we, in the background, figure out administratively on our side, and kind of think about a process and stuff, and fill those gaps in. That is what I wanted to accomplish today in this meeting, and I think it was a heavy lift, and I really appreciate everybody's discussion and involvement. I will be sending out a doodle poll soon to schedule the next meeting where we talk about the expungement side. So we've dealt with the website side. We have more understanding on the levels of discipline. And then now we can kind of talk about the actual expungement time and how it relates to the Supreme Court and explore that. So does anybody
Justin,
else? Yes.
because I was having technical difficulties and I was listening for half an hour or so, I didn't see a lot of the slides. So I would really dearly love to get a copy of those via
Sure.
email after this meeting, because and by the way, I wanted to thank the staff and you for putting it together, because it sounded really comprehensive and really great and exactly what we were looking for. But I would love to just sort of get a copy.
Yeah, I'll send both slide decks out after this meeting to the
Thank you.
working group. Okay, unless anybody has anything else, I think we are adjourned. Thank you, everybody.
Thank you.
Thank you.